Good morning. This is Marcia Waters. I'm the Division Director for the Division of Real Estate. I'm calling the Board of Real Estate Appraisers meeting to order. Today is Thursday, July 18th, 2024. The time is 9:05 a.m. and I will kick off with the determination of a quorum. Clint Taylor.
Here.
Daisy Glassburn.
Here.
Brent Goff.
Here.
Rob Stilo.
Here.
Darius Wise will be joining us later. I believe I've gotten everybody, so we do have a quorum. The first item on your agenda today is approval of the May 2nd meeting minutes. Do I have a motion to approve the minutes?
This is Brent Goff. I'll make a motion to approve.
I have a motion. Do I have a second?
This is Clint Taylor. I second. Oh,
okay.
Sorry.
I have a motion and a second. Is there any discussion? Seeing none, I'll take a vote. All in favor to approve, say aye.
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 Any nays? The minutes are approved. And then the next item on your agenda is other matters, which you don't have any on your agenda. So we're just going to go ahead and move into policy matters, which will lead us off with selection of leadership. So today you all need to vote in a chair and a vice chair. So I will turn it over to you guys for discussion.
Daisy, you should be the chair. You get my vote.
I could second that. This is Clint Taylor.
This is Brent Goff. All in favor, say aye.
Okay, so we've got a motion and a second, a vote to make Daisy the chair. All in favor, say aye.
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 Okay, that motion passes. Now you need to select a vice chair.
Brent, how about you? You've been here long enough.
Well, just as long as you. You want to do it, Rob?
Sure.
Okay. I'd like to nominate Rob Stilo for vice chair of the Colorado Board of Appraisers.
Do we have a motion? Do we have a second? Daisy's a second. All in favor, say aye.
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 Any opposed? Motion passes. Rob is the vice chair. Daisy, would you like to take it over, or do you want me to run the meeting?
You know, for this first one, it'd probably be better if you did.
Okay. So the next item on your agenda do you have anything that you would like to discuss at your September board meeting?
I don't have anything.
Okay. So that takes us to the citizen participation period. Any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board, and the board may allow public comments, you typically don't allow public comment on the agenda items, particularly complaints, because we have a policy that dissuades about that. But David, do you want to see if there's any public comments or anybody signed up to give public comments?
Thank you, Director Waters. Any members of the public, if you would like to make a comment, please raise your hand by clicking the raise hand icon. That should be at the lower part of your screen, and we can unmute you. Director Waters, seeing none, I don't believe that I know we don't have any hands raised, so I will hand it back to you.
Okay, so that moves us into complaint investigations. Give me just a minute. So complaint matter A is case number 2024-430. This is an investigation completed by Rob Walker. The complainant alleged the respondent was negligent and incompetent for failing to consider properties outside of the subject's immediate neighborhood and did not make appropriate condition and RV garage adjustments In reviewing the report and the work file, there appeared to have been numerous potential USPAP violations, including the ethics rule, scope of work rule, the record keeping rule, and multiple violations of standards rules 1 and 2, as well as state statutes. The potential ethics rule violation was knowingly communicating a misleading report. The respondent failed to adequately research, document, and analyze the market area, the current market conditions, and the subject's amenities. There was no documented support for any of the adjustments or the lack thereof in the sales comparison approach. The cost and income approaches were reported to have been considered, but ultimately were not developed. Possible violations include 12-10-613-1G, failed to comply with USPAP, the scope of work rule, the record keeping rule, the competency rule, the ethics rule, standards rules 1 and 2. Staff recommendation is for a stipulation for diversion, a $500 fine, and coursework as the following: 15 hours of the National USPAP course, 7 hours or more of comparative analysis and or supporting adjustments, and then a class titled That's a Violation that is 4 hours. Rob is here to answer any questions that you may have.
Rob, this is Brent Goff. Were there any prior infractions from this person? Any prior complaints?
Rob's on mute.
No.
Rob, you're on mute. We're still not able to hear you, Rob. Can you unmute?
There we go.
Yep.
It's success. Let me take a look at. There were no earlier violations.
Okay, thank you, Rob.
Board members, if there isn't any other discussion, do we have a motion?
This is Rob Stylo. I motion to accept the recommendations.
There's a motion. Do we have a second?
Yeah, this is Brent Goff. I'll second that.
We have a motion and a second. Any discussion? Okay, we'll take a vote. All those in favor say aye. Those opposed say nay.
Aye.
Aye.
Any nays? Okay, that passes. So complaint matter B is case number 2024-702. This was an investigation completed by Rob Walker. The complainant alleged that the respondent inappropriately selected the comparable sales, inaccurately described their features, and did not properly support the adjustments. In reviewing the work or the report in the work file, there appeared to have been numerous potential USPAP violations, including the ethics rule, the scope of work rule, the record keeping rule, and multiple violations of standards 1 and 2, as well as state statutes and board rules. The potential ethics rule violation included knowingly communicating a misleading report, appraising to a predetermined value, willingly violated the record keeping rule, and did not exercise due care to prevent the unauthorized use of his signature. The respondent failed to adequately research, document, and analyze the neighborhood market area, the current market conditions, and the subject's amenities. The adjustment support had an effective and analysis date of November 7th of 2023, 7 months after the report's effective date, and several of the analyses did not correspond with the adjustments made in the report. The opinion of the site value was not properly analyzed, and the respondent or the replacement costs were not supported in the cost approaches. Finally, the complainant provided an appraisal report with the respondent's signature dated January 5th of 2024. However, the respondent had no record of that report and stated that he had no memory of signing a revised report. Potential violations include 12-10-613-1G, failed to comply with USPAP, the ethics rule violation, the scope of work rule, record keeping rule, standards 1 and 2. Recommendation is for a dismissal with subsequent education. The education consisting of a 15-hour national USPAP course, 7 hours or more of comparative analysis and supporting adjustments, reliable record keeping, and a course called That's a Violation that is 4 hours. Rob is here to answer any questions that you may have.
Rob, is this a typical recommendation for when I was going through it, it seemed like some egregious misleading items in the report.
Well, actually, Marcia makes the recommendations. We don't do any recommendations ourselves. We just do the investigation. There were a couple of significant issues, I would say. Probably one of the most disturbing was not securing his signature and potentially allowing somebody else to adhere his signature without approval or his knowledge. That was pretty bad. Also, the use of sales price as a search criteria, also frowned upon, shall we say.
Mm-hmm.
There were some pretty hefty quality adjustments, weren't there, in this?
There were, and I think this is kind of a pretty difficult neighborhood because there's a diverse range of values, all at the same price or the same size, but varying degrees of price point. So it just wasn't very well supported on anything he did, and that was probably the main thing. And then it appeared there was potential cherry picking of comparable sales to use to achieve a value close to the contract price.
Hey, Rob, it's Rob Stylo. Did you ever figure out who signed it or who has the original, who has the copy from January?
No, because actually he no longer works for the appraisal company. I spoke with the former owner of the appraisal company. She was out for an extended medical issue. So basically she said their office manager was basically in charge. She didn't particularly accuse have any accusations. She did say he was let go soon after she returned. Basically, I spoke to other people in the office. They said, they would be surprised if he would allow somebody to do a signature, but at this point, they weren't able to. I believe it was Fannie Mae was the complainant. They provided the updated report, but neither the respondent or this appraisal company was able to provide that. They had no record of it.
And
Somebody did it.
He went out and ventured into business with the manager that was let go. Is that what I read?
That's what it appears. Yes.
So board members, the reason that I recommended what I did is due to the fact that he has only been credentialed since 2021. And part of these may have been a training issue. You Absolutely. Are by all means able to deviate from that recommendation.
So Marcia, on that, so a dismissal with subsequent education, does that mean that his record, he won't have a violation? Like if 3 years from now there's another problem, this issue here today won't be of record?
So it won't be a public record, but as far as we do report those to you all, if there is a subsequent complaint. So it's
Okay.
to let you know that you've already addressed something with them once. And typically, depending on how long in between violation or complaints, we also try to update you on what the previously ordered education was so that you can see whether it made any difference or not in subsequent violent or subsequent cases.
Okay, that makes sense. Thank you.
So board members, is there a motion?
This is Clint Taylor. I vote to agree to the motion or agree to what Marcia, you've recommended.
There's a motion. Is there a second?
Yeah, this is Brent Goff. I'll second the motion to approve the recommendations from Marcia.
So there's a motion and a second. Is there any discussion?
I was just wondering what other options we had in terms of that.
So you have
Is it-
a wide array that you can deal with. Dismissal with education is kind of the lowest, kind of
Right.
in your range. You can do a stipulation for diversion that is subject to an open records request. There's a final agency order that is the discipline that appears on the website. But in addition to this, you could order work product review, you could order supervision, you can suspend a license, you can require additional education, you can require the payment of a fine. I mean,
I would think some sort of work check or would be appropriateness. There were a lot in there that seemed intentional.
So if you want to do a work product review, then what we'll be looking at is either a stipulation for diversion or a final agency order. We don't do that type of remedial requirement with a dismissal with education. Because the stipulations hold them accountable to completing that work product.
Right.
With the extensive amount of stuff that was brought up, I think a review might be appropriate. I'm more worried about the training portion, right? On, what was missed, since he is pretty new to appraising. It seems that's a lot to miss right off the bat.
Well, not even in addition to the fact that he doesn't know where his signature is even more so egregious. So Daisy, going back to your question, which, I'm glad you brought up, maybe we do look at some further review of this, or at least having somebody supervise the work product to make sure that the signature is there, as well as also making sure that the knowledge is following suit.
So if you do work product review, what you'll need to decide is how many appraisals you want reviewed over what span of time. And that is, work product review is different from supervision. So just keep that in mind as well. Supervision is kind of higher up on the list as far as kind of more significant than the work product review, because then they are having to work with another appraiser who's actively supervising them with the supervision.
So could we do a minimum work product review with whatever timeframes appropriate, but not extensive, but just a glance at some current reports by another appraiser? Obviously not the one that he's partnered with, but someone else.
So you can make that stipulation as well, that the work product review cannot be done by his associate. You just need to figure out like how many appraisals do you want. Typically, I think we go for about 4 over 2 months.
I think that would be good.
I agree.
So does somebody want to amend the current motion, or do you want to vote on the current motion? And if that fails, then you can do a new motion to add the work product review and do a stipulation for diversion. Do you want me to give you an idea of what an amendment would look like?
Yes,
Please.
So an amendment to the motion would be basically that you want to change it to a stipulation for diversion with work product review of 4 appraisals in 2 months. And then the coursework recommended is 15 hours use PAT, 7 hours comparative analysis and or supporting adjustments, reliable record keeping, and that's a violation. So Brent or Clint, Clint made the motion, Brent seconded. Do one of you want to amend your motions?
Yeah, this is Brent Goff. I'll do it. In light of discussion, I'd like to amend the punishment, if you will, to a stipulation for diversion with the classes and coursework listed on the original documentation required.
And that the work product review will not be performed by his business associate.
Okay, and that agreed, the work product review would be performed by someone else other than his associate.
Okay, so we have a motion and a second. Any further discussion? Okay, all of those in favor say aye.
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 Okay, that passes. So the next complaint is case matter C. This is case number 2024-393. Scott Wentz is the investigator for this one. On February 21st, 2024, the respondent self-reported to the board that her appraiser's credential in Minnesota had been subject to discipline. The respondent provided copies of the order dated to show cause dated June 8th, 2023, alleging violations of the Minnesota statutes. The state portion of the civil penalty in the consent order dated required payment of $3,500 to the state of Minnesota within 6 months of signing the consent order. It also required the completion of 12 additional continuing education courses approved by the state of Minnesota beyond the required continuing education courses mandated by the state within the next 6 months. Payment of the civil penalty to the state of Minnesota within 6 months of signing the consent order in the amount of $10,000, $5,000 of which was stayed pursuant to the terms. The stay of the portion of the civil penalty may be lifted if there is no further violations of any law, rule, or order. The respondent's real property appraiser license was suspended for a period of 30 days commencing on February 10th of 2024. The respondent was required to pay all investigative costs in the amount of $950 at the time of the consent order being signed. The respondent was further ordered to cease and desist from violating any laws, rules, or orders. This consent order is effective upon signature on behalf of the Minnesota Commissioner. On February 29, 2024, the parties notified the administrative law judge that they had settled the matter and the case was dismissed with prejudice. Possible violations are Board Rule 13.5 and Board Rule 13.4. I also believe that there's a statute violation, which I will look up really quick while you guys discuss this. Of note is that previously on January 6, 2022, the board issued a letter of concern because it was discovered during the review of an applicant's experience that the respondent was acting as a supervisor and had her license disciplined in Minnesota and failed to report the discipline to the board. So Scott is here to answer any questions that you may have, and I am going to quickly look up the statute violation that pulls in the board's rules as a violation.
hey, Scott, Rob Stylo. Hey, our notes say she failed to report, but the attorney letter said, what did she say? They believe their client's only responsibility was a self-report, which she did.
Right. So I've got the same letter that was issued by her attorney, which was Patrick Boyle, which was dated, it looks like February 26th of 2024. She did self-report it. I had been on the phone and also various emails with the state of Minnesota and over the last couple months. And also I've been in contact with the attorney, and they basically, I asked for some additional information as so forth as far as some of the orders of consent. And the gentleman's name was Matt Boyer, who's the audit director for the Minnesota Department of Commerce. I spoke with him on June 28th of 2024, and he indicated that there were two different cases. There was the case from 2022 and then the current case. The first case was 234-629, and the latter case was 41869. Apparently, for the 234-629, she still owes $3,500 on the first case, which is due by August 26th of this year. She has paid the investigative cost of $950 on the case 418-269. She had a fine of $10,000. They stayed $5,000 of that, and she still does currently owe the $5,000. And then in addition, they did order her to remedial of 12 courses. Yes, that's correct. 12 courses, not 12 credit hours, that need to be completed by 8/26 of 2024. So there was a little bit of confusion, and I'd reached out to obviously the respondent and the respondent's attorney, and their basic comment to me was that she didn't admit any wrongdoing on her part as far as the consent orders. So if that answers your question, sir.
And Rob, just to make clear, if you all like to go into executive session, we can wait for Darius to get here so we can vote to do that if you'd like more fulsome legal analysis. But her attorney was incorrect. Rule 13.4 requires that when the board reaches out to a licensee and asks for information, the licensee has to provide that information. And there's no right to just state, well, we didn't admit any wrongdoing or this has been settled. The board sought details and they refused to provide them, which is what Rule 13.4 requires.
So board members, what we need to add as a potential violation is 12-10-613-1B, which pulls your rules, and that's as far as a violation is concerned. I didn't have a recommendation for this one just because this is kind of unique and we don't typically see these very often. You've already given her kind of a warning from the prior case.
Yeah, this is Brent Goff. Scott, did I hear you correctly that she was required to take 12 courses and she's taking them right now?
That is correct. So like I stated earlier, I actually got in contact with Matt Boyer, who is the audit director for the state of Minnesota Department of Commerce, through various emails and various phone calls. And that is correct. She's required to take remedial education of 12 courses. Again, that's not 12 credit hours, that's 12 courses, and they needed to be completed by August 26th of 2024, sir.
Thank you.
Is there a total number of hours that those 12 courses need to equate to, or?
No, and that was some of the confusion back and forth with Mr. Boyer, who is the audit director. He just stated, he said that and basically in Minnesota they do an order of consent, and he stated again to me that it was 12 courses that she was required to take, and he did not indicate the total credit hours and so forth. And I again asked him again, I said, well, is this 12 credit hours or is it 12 courses? He said it is 12 courses, and he was not at liberty to discuss as far as which courses she was required to take.
Okay.
And we don't know where excuse me, we don't know if and where she's at in the progress of those, because she only has till next month basically to finish those 12, correct?
That is correct, sir.
So I don't, this is Brett Goff. I don't see any recommendation for action on the Colorado board's part. It looks to me like the state of Minnesota is sufficiently correcting this individual. Do we have to impose anything, or can we just monitor this licensee? What are our options, Marcia?
So You've previously warned her about not reporting discipline in another jurisdiction to us. This time she did report it, although she didn't provide you with the documents as required. So you can do an outright dismissal if you'd like to. Another letter of concern, which is it's a dismissal, but you issue kind of a warning letter. You could do a letter of admonition. You don't use those very often, but that's that's a notch up from a dismissal with a letter of concern, because that becomes record. And basically it states that there was a violation, but she chose not to pursue any formal discipline. She does have the ability to want to take that to hear. If she wants to take it to hearing, she can. But that would probably be kind of the next thing up from a letter of concern in the dismissal realm. Usually your stipulations are going to have some sort of stipulated terms, like a payment of a fine, public censure, education. So what you may want to consider is doing a letter of admonition at this point.
And
I think that sounds like a good idea, but
okay. Has she followed up with the documentation after we told her that we didn't get it?
No, Scott didn't get anything further. If we'd gotten anything, we would have given it to you all.
Okay. Yeah. I think if we do a letter, we should require her to submit that documentation in that letter.
is that ultimately giving her essentially just asking her again, and she would be able to refuse that? Is
this the letter of
that okay?
admission? Or
Yeah, they're just, so typically a letter of admonition doesn't have any follow-up terms. There's statutory language that's involved with those. It basically puts them on notice that you found a violation of the statutes, but you're not going to take formal action. I don't know at this point if you actually need the additional documentation that Scott had asked for. I know he spent quite a bit of time on the phone with the state of Minnesota. So it may just be sufficient at this time to do the letter of admonition, which she is in turn going to have to report to the other jurisdictions where she's licensed.
I see.
I think that's fair.
So Scott, you don't need the documentation. You basically did all the investigation that gave you the information, and it wouldn't be helpful at this point to ask her to do that.
That is correct, sir. I like I said, just with follow-up emails and phone calls to the state of Minnesota, I actually got both of the orders of consent for both of the cases, in some of the actual charging documents. So I've gotten all of that. It like Marcia commented, it took a couple months, and going through various people with their actual division. In fact, I think the first person that actually adhered to some of my questions was the Matt Boyer, which is the audit director for the Minnesota Department of Commerce.
Okay.
So the violation to us is not self-reporting, correct?
Correct. She self-reported. The violations, though, are not providing the board with the documents that were requested, and then also the fact that she was disciplined in another jurisdiction. So is there a motion?
This is Daisy. I'll make the motion to for the letter of admonition.
There's a motion. Is there a second?
This is Clint Taylor. I'll second that motion.
There's a motion and a second. Any discussion? Okay, seeing none, I'll call the vote. All those in favor say aye. Those opposed say nay.
Aye.
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 Okay. So complaint matter D is case number 2024-191. Scott Wentz is the investigator for this. On January 8th, 2024, the respondent was convicted of murder one after deliberation attempt. This is a violation of 18-3-102. A class 2 felony and a violent crime using a weapon was a sentence enhancement for this case. The division was alerted to the arrest via CBI report and does not have a record of the licensee notifying the division. The respondent was fined $441.50 and sentenced to 25 years in the Department of Correction. Potential violations are 12-10-6131K, engaged in conduct that would be grounds for the denial of a license or certification, 12-10-6331B, violation of Part 7 or a board rule, and 13.7, this is the board rule requiring licensees to report criminal convictions within 10 days of a guilty plea or a guilty verdict. We don't have a recommendation for you because this is unique, so we're waiting to hear what the board has to direct to us. But Scott is here to answer any questions that you may have. And I do believe that this respondent in the past, let me pull it. My cases are getting, I'm pulling up the wrong files. I know in the past he has had some issues with the board. But it's
I was going to ask that question. And the date of this crime occurred was in 2020, correct?
That is correct.
That's correct. Okay. He's currently incarcerated, right?
Yeah, he's currently incarcerated at the Crawley County Correctional Facility, which I believe is a private prison. And I had sent a letter of notification out to his email address originally, and then actually a hard copy versus in the US mail, it looks like on January 27th of 2024. And then later when I found out, when I was asking the director, Marcia, I went ahead and sent a letter to the Crowley County Correctional Facility. It looks like it was on May 6th of 2024 to see if we could get some letter of explanation or some comments from the actual respondent.
The board members,
Which you did not, right, Scott?
That is correct. I did not receive a response back from the respondent at all.
Okay.
Well, this is Brent Goff. I think this is the biggest violation of public trust I've seen on my time on the board, and it reflects poorly on licensees in general and poorly on the appraisal profession. So he's already inactive on his license, right?
Correct.
He's probably indigent, doesn't have money, but I think we need to communicate that in probably the most emphatic way, or displeasure of this kind of behavior for any licensee. And how do we do that? Would we write a letter of admonition? What's the strongest thing we can do in writing?
Well, so the most significant form of discipline you can impose is a revocation of the license.
Okay, he's inactive though, right? Already?
True, but you still have jurisdiction over him. I mean, he could activate his license.
Oh, yeah, let's do that.
Typically,
Yeah.
you revoke a license, you impose the maximum fine, so to give you guys some background, he had a stipulation for diversion back in 2011, and he had a letter of concern, which was a dismissal back in 2012. So it's been quite a while since he's had anything before the board. Zach can speak to this as well, but I think one of the things you also need to consider is, like, does the crime involve appraisal, which with Scott didn't get a whole lot of details based on the documents that the courts provided as far as kind of the underlying circumstances, but this does not appear to be appraisal related. So if you want to revoke him, typically what we do is it's a final agency order with public censure, revocation, and a maximum fine, which would be, I think, $1,000 per violation at this point with your the statute changes that were made a few years ago. So you'd be looking at about a $3,000 fine for him.
Although it's not appraisal related, in terms of the public trust, I mean, and if you engage in a conduct that's grounds for not getting a license, isn't it also grounds for revocation?
You would still have grounds to pursue that type of discipline against him. It does speak to public trust and also public safety.
I think revocation is certainly warranted in this case.
So do I have a motion?
Yeah, this is board member Brent Goff. I make a motion to impose a revocation of license and a $3,000 fine. If we could put something in writing that would be the most emphatic, that would communicate our most emphatic displeasure that a board member would be engaged in this kind of, I'm not a board member, a licensee would be engaged in this kind of conduct. I'd like to have a letter sent to him issuing the punishment and our displeasure and the fine and the revocation.
This is Daisy. I'll second that.
And real quick, this is Zach. I just want to be clear. That also includes an FAO and public censure, correct, Brent?
Explain the FAO for me.
The FAO will be like attached to the license, the final agency order. So it'll say if you search this person's license on the website, it'll come up that this happened. And then public censure means it's published so that others see that this occurred.
Yes, let's add that.
Okay. So I just want to be clear, just so the record's clear. So we are voting on revocation, $3,000 fine, an FAO, and public censure.
Yes.
All right, thank you.
So we have a motion and a second. All those in favor say aye. Those opposed say nay.
Aye.
Aye.
Okay. And let the record reflect that Darius is back now. Darius, welcome back. We are on complaint matter E. Complaint matter E is case number 2024-660. This was an investigation completed by Rob Walker. The complainant alleged the appraisal report dated June 28, 2022 was actually written in February of 2024 as part of his client's tax assessment appeal effort. In reviewing the report in the work file, there appeared to have been numerous potential USPAP violations of the ethics rule, scope of work rule, record keeping rule, and multiple violations of standards rules 1 and 2, as well as the board rules and statutes. The respondent failed to adequately research, document, and analyze the market area, the current market conditions, and the subject's amenities. The report did not contain the specific criteria used to determine comparable properties, nor was there sufficient commentary concerning the selection of the comparable sales used in the report. In the sales comparison approach, there was no adjustment analysis, with the only support being the opinion of the construction company estimator. The reason for not developing the cost and income approaches was because buyers typically don't consider them. Finally, there are insufficient summaries of analysis to support the opinions and conclusions made in the report. However, the most concerning aspect of the report was the potentially numerous ethical violations. Possible violations include 12-10-613-1G, failed to comply with USPAP, and you're going to have 12-10-613-1B, violating a board rule. Board Rule 12.12, the ethics rule, the scope of work rule, the record keeping rule, and standards 1 and 2. The recommendation is for a stipulation for diversion with coursework in 15 hours of the National USPAP course, 7 hours or more of comparative analysis and or supporting adjustments, 7 hours or more in sales comparison, and then residential report writing and case study. Rob is here to answer any questions that you may have.
Rob, this is Brett Goff. So the client for this initial appraisal for the tax appeal, was that written down and stated? And did he change the client on his second report to a different person? Is that what happened?
It appears that it's the same client. It looks like there was an initial appraisal that was done earlier, and then when the client wanted to appeal his tax amount, he kind of ordered a second appraisal, but basically what they just did is they just used all the information on the first appraisal, adjusted a few things so it would fit within the dates of the time frame, and basically passed it off as pretty much as a new appraisal.
Okay.
And actually, the intended use, in the report says it was, current market value for the subject property for client's personal use. It didn't mention anything about, a potential tax appeal.
Okay. Because they're always retrospective on the
Right.
comp selection for the tax appeal. And so he must have got a call from the client and said, I want you to do some more work. And he should have at that point said, this is a new assignment and I can't really clone your old tax appeal. Is that what he should have done?
Well, I mean, he should have. The main thing is he had the wrong date on it. So I mean, it wasn't properly certified. Also, I don't think there was anywhere in the report where I actually said it was a retrospective report either. So there were a couple issues there. Because I mean, basically, the report was dated, and you can tell that it was basically a clone report with just a few different things moved out. If you would have properly adjusted things, maybe said, hey, I have done a report within the prior three, assignment. A lot of it's just simple certification issues that he certified that he did these things when in actuality he didn't do any of them.
I see.
Hey, Rob, this is Rob. It looks like he said, if the board wants to discipline me for USPAP violations, may I suggest they revoke my license? Looks like not continuing in the profession.
Yeah, it's he had it appeared to a lot of personal tragedy somewhat recently. I don't so it's basically I don't care anymore. Was the I don't know if that was mainly due to his current emotional state because of the family tragedies, or whether that was truly his intent to leave the industry.
You did not get a chance to interview him?
I did not, which that is he provided his work file, but we don't require people to interview it, but it can help as far as them to further explain their reasoning and support the things that have been done. He chose not to.
Okay.
Yeah, it says right here he's retired from the appraisal profession and will not be renewing his license. So, yeah, like you said, Rob.
So if we just motion to accept this, odds are he's bailing anyways, is how I
Yeah.
read it.
You can have a discussion though with Penny about, the board rules allow somebody to surrender their license or relinquish it pursuant to board rule 8.8. And if he has that discussion with Penny, then it's going to come back to you to see if you'll accept that relinquishment. But for purposes of the appraisal subcommittee, you've got documented potential violations that you need to address. So is there a motion?
I motion to accept the board recommendations.
There's a motion. Is there a second?
I'll second.
We have a motion and a second. Is there any further discussion? Okay, seeing none, I'll take a vote. All those in favor say aye. Those opposed say nay.
Aye.
I,
So board members, that takes us to complaint matter F. This is case number 2024-714. The investigator for this is Rob Walker. The complaint alleged the respondent obtained a certified residential appraiser license in the state of Colorado in an attempt to circumvent the state of Oklahoma's application process by applying for a reciprocal license. The respondent had applied for a license in Oklahoma in November of 2022. All applicants were required to submit 2 appraisal reports for review as part of their licensing process. In reviewing the reports, there appeared to have been numerous issues. A grievance was opened by the Oklahoma Real Estate Appraisal Board on November 1st, 2022 for potential USPAP violations of the ethics rule, the scope of work rule, and the record keeping rule, as well as multiple state statute violations. On March 4th of 2024, the board concluded that the respondent and a supervisor had provided a report that had been embellished and supplemented. It was also decided that due to the material misrepresentations in the report, the work log could not be relied upon for his experience hours. The respondent's supervisor's license was officially revoked in May of 2024. The respondent applied for a certified residential license in the state of Colorado on August 28th of 2023. On his application, he denied ever possessing an appraisal license or being the subject of an investigation. He also provided an incorrect residential address in Colorado. The respondent admitted that he had not been in the state of Colorado since 2018. Also, the address used was actually the office address of an appraisal firm that has been the subject of a board investigation. Possible violations include 12-10-613-1E, false application. Staff recommendation is for a revocation of final agency order, public censure, and a $1,000 fine. And Rob is here to answer any questions that you may have.
Rob, this is Brent. Did you interview this person, and did he have any kind of contrition for what he did or any explanation?
I did interview him. He spoke at length. Did not really, it was more kind of justifying the actions and saying that, there was misinterpretations by the state of Oklahoma. Did not appear to have much contrition. Didn't really address, basically it was a big misunderstanding by the board, and I think my major concern was the fact that he was less than truthful on his application for the Colorado license.
Yeah, and it was somebody else's fault, not his, right? According to him.
According to him, like one of the reports that was done by Oklahoma was, an earlier version, it was the bank's fault for sending him the earlier version and that sort of thing. So, there's, personal issues going on and,
Okay.
Yeah, sounds like he has some major personal issues with his wife and himself from a physical standpoint as far as health wise. But again, as you stated, Brent, as well as also the fact that he's less than truthful is not a good thing, and the fact that he's not owning up or taking any type of responsibility or showing any type of moving forward, anything productive of what he had done and what occurred is a concern.
Yeah.
And his Oklahoma license was revoked already.
he had a trainee license. I think it was expired. His supervisor or one of his supervisors, and that was kind of a muddied issue as well as who was the first one, who was the second one, was also revoked. His license was revoked, and basically the state of Oklahoma has been saying, at this point, we're not really ready to accept, give you licensure either, just based on that. So it appears that basically it's like, hey, Colorado's easy to get a license, maybe I'll try that, and then get a reciprocal license in Oklahoma. That was their main concern, because it does not appear that there's really any real chance of him using his license here, and the only reason was to get it, being able to get a reciprocal license in Oklahoma.
All his experience was from training was in Oklahoma, though, as well.
All the experience that he provided to us was from Oklahoma. He did say that there was, he did some training with an appraiser here who is
He's a pending revocation.
Pending revocation. It was kind of, I did kind of look, and they said basically Oklahoma had a problem with his experience log. I went back and took a little bit close look at his experience log, and if he would have done all of this work, he would have worked, had to have worked 7 hours a day, 7 days a week for like 7 months, to get this experience. So there may have been some fudging on that as well.
Thanks.
I don't feel that I trust that his experience is there. In my opinion. Marcia, what is where are we at right now as far as what we're trying to, is it $1,000 fine, public censure, final agency order revocation? Is that what we're recommending right now?
That's correct.
And since he has an active license, are we aware that he's actually done any appraisals in Colorado?
So we don't know what he's doing. I mean, they're not required to report the business that they do with us, but he does. If you vote to revoke, he's going to have that license until he either signs a stipulation with us or we go through the hearing process and a final agency order is issued.
I see. Well, this is Brent Goff. I would make a motion that we accept the staff recommendations for revocation, public censure, and $1,000 fine.
No final
This is
agency.
Daisy, and I'll second that.
This is Zach Fitzgerald again. Just to confirm, this also would include a final agency order, correct?
Yes.
All right, thank you.
So there's a motion and a second. Is there any further discussion? Seeing none, I'll take a vote. All those in favor say aye. Those opposed say nay.
Aye.
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 So board members, that concludes the complaint matters. You don't have any licensing matters for your consideration today. That moves us into the expedited settlement program matters. And Penny is here with a stipulation violation.
Good morning again, folks. This is a stipulation violation case. There was a final agency order issued in October of 2023 that required the licensee to pay a fine. There was a period of suspension, then to be followed with coursework and a period of supervision. The individual has, the suspension ran. During the period of suspension, his license ultimately expired. So that's why his current status is expiration. We have had contact with the individual. They have communicated with our staff, so we are fully aware that they are receiving the information and know of the obligations, but are disregarding those obligations. So the recommendation is to proceed forward with a violation of 1210 613(1)B, which is a violation of the order, with a recommendation of revocation and a fine of $1,000, which would be through a final agency order with public censure. And if you have any questions, I'll do my best to answer those. Just a note also, and I apologize, there is a typographical error on the memo that I provided. It says the fine is in the amount of $500 with the 15% surcharge. It says the remaining balance is $75. That should be $575. There has been no payments made whatsoever, and none of the coursework has been completed. And obviously, none of the supervision as well.
This is board member Brent Goff. Make a motion that we proceed with the violation of 12-10-613 paren 1 paren B, indicating a violation of the stipulation.
And board member Goff, do you want to, does that motion include the recommendation to revoke and impose a $1,000 fine along with a final agency order and public censure?
Yes.
Okay.
I'll second. Darius Wise seconds.
So we have a motion and a second. Is there any further discussion? Seeing none, we'll take a vote. All those in favor say aye. Those opposed say nay.
Aye.
Aye.
Okay, that motion passes.
Thank you. That's all I have.
So board members, there aren't any attorney general matters and you don't have executive session. So unless you have something that you would like placed on your next agenda, we can adjourn this meeting and we will see you all on September 5th at 9 a.m.
Marcia, can I ask a quick question on, and sorry I missed this. Thanks for giving me the ability to tend to that staffing matter. The selection of leadership, can you remind me of who's chair? Did we appoint any of those roles or what was the outcome?
We did. So Daisy Glassburn is the chair and Rob Stilo is the vice chair.
Love that. Congratulations, guys. Thank you for stepping up.
Sure.
Anything further, board members?
No, thank you, guys.
If not, we'll adjourn. Thank you very much for your time today.
All right.
Thank you. Enjoy your rest of your summer,
All right.
guys.
Bye-bye.
Yeah, you too.
Well, take
Bye.
care, guys.
Take care, guys. Bye.
Bye.